We talk to our clerks about it, what do you think about this argument? What do you think about that argument? We go back to the books. If you go into any of our offices, you'll see the walls are lined with these books that are the Supreme Court decisions, the other federal court decisions, other state court decisions. And we look up to try to find cases that are like this one, and how did that case come out? What did the justices say then? And we get ready for the argument. And then an argument set for a particular day, and we usually haven't talked about it among ourselves. We go out to the argument, and then for the first time, through the questions, we learn what each other of the justices thinks about the case. Justice Ginsburg might ask some questions, and you suddenly think, oh, she thinks this is a problem. Maybe I hadn't thought of that as a problem before, so you start thinking about it a little more. And maybe Justice Souter will ask a question in a different direction, and the lawyers will try to give the right answers or answers that help them, and you can see how good those answers sound. You might have particular questions. When you were looking into the case, you thought, well, I wasn't really sure whether that lawyer made the right objection when the case was tried, so I'll ask that question. And you ask, you say, well, counsel, did you object to this below? And if so, where? Where in the record? And you have to be able to say, page 258 of the appendix, you'll see that in the transcript I made that objection, or I didn't. Well, why not? And then the argument ends. And we go twice a week. When we're hearing arguments, we have what's called a conference. We hear arguments Monday, Tuesday, and Wednesday. And on Wednesday afternoon, we have a conference about the cases we heard on Monday. And Friday, we have conference about the cases we heard on Tuesday and Wednesday. And again, it's just the 9 of us around the table, and we go in order. I get to start, so I will say, we heard argument in this case about the Fourth Amendment from Pennsylvania, and this is what happened. This is what the arguments are, and I think we should reverse the court, because I think they got it wrong. Next, Justice Stevens, who's the next in seniority, he'll say what he thinks. And he'll say, well, maybe he agrees with me, maybe he disagrees. If he disagrees, he'll say why. He says, I think this case shows we ought to affirm, and he'll explain why. And then down the line, Justice Scalia next, Justice Kennedy next, Justice Souter, all in order of seniority, and we talk about it. We have a very strict rule that nobody gets to talk twice until everyone's talked once, because you can imagine with 9 people sitting around, otherwise everybody just start talking at once. So we go pretty much in order, and then we vote. And that's our tentative decision. Now, you asked who decides who gets to write the opinion. That's really the only special power I as the Chief Justice have. I get to decide who writes the opinion for the court. So let's say it's 6-3. And at the end of that week, I'll go back and say, well, Justice so-and-so should write the opinion in this case, Justice so-and-so should write in this. Now, if I'm in the minority, if I'm with the 3 and not with the 6, then the most senior of the other justices gets to assign the opinion. Then we will occasionally talk about it. You see it, justices either in writing, talk about it in writing, write memos saying, you made a point at conference that you thought it should be affirmed for this reason, but what about this case? That seems to go the other way. I think we should reverse it, and send that around, and people reconsider it. It's not at all unusual for us to change our minds as a result of that process, and somebody's trying to write the opinion. The opinion is an important part of the decision process. It's not like we decided finally at 6-3 and now we write one opinion that says why and another opinion that says why you think it should come out the other way. In the course of writing the opinion, justices might decide that that's not quite right. I thought this was the case, but I had to write it down, and as I wrote it, it became clear that maybe this should come out the other way, and people will change their minds. And once all the opinions have circulated around and the other justices have joined one opinion or the other, when it's finally ready to come out, we'll go into court during an argument day and announce it. And I'll say, today, Justice so-and-so has the opinion of the court in this case, this Fourth Amendment case from Pennsylvania, and that justice will read a summary. The opinion might be 20 pages long, but they'll just give a short summary announcing the decision, and that becomes part of the law of the land. I think justices change their minds a lot of times throughout the whole process. Certainly you read the first brief, the blue one, and you think, that sounds right. The court really got that wrong. Then the red brief comes in and you read that and you say, well, those are good arguments. I hadn't thought of that. Now it doesn't look so clear. Then you go to the argument, and maybe at the argument you learn something new from the lawyer, or you learn something from the questions that your fellow justices are asking, and you say, well, now it does look like they got that wrong. Then you have to sit down at the conference table, and you have to explain what you think ought to happen. And you listen to the other justices, and sometimes, quite often, they have particular points. You say, oh, I see that a little bit differently. And you can ask them questions, they can ask you questions. And again, you might change your mind at that stage. Then the opinion comes around. Okay, I'm tentatively voting that we should affirm, and assign the opinion to somebody. And the opinion comes and you read it and say, well, that doesn't sound quite right. I'm not quite persuaded. And then the dissent comes, and that's arguing the other way. And you say, well, that sounds a little more persuasive. Maybe I should change at that point. So at any part of the process, the justices do change their minds as new information, or as they learn more about it, or they hear more what their colleagues think. It affects the ultimate decision quite often, quite often.
I understand that you spoke about opinions and who's assigned to write and deliver it, but my question is, why is it important and why is it necessary to deliver an opinion?
It's critical for a couple of reasons. One is that it helps us decide the case correctly. I mean, it's no different than if you get a bunch of friends together and you're trying to figure out some issue, whether for a debate or something, what should the answer be? You can talk about it and kind of decide it, and you say, fine. If you have to sit down and explain it, it causes you to focus your thinking quite a bit, I think. And if you have to explain it in a way that's going to be understandable to other people, that helps make sure that you're reaching the right decision. It's not just the result of some, casual conversation, but you actually have to explain it. And sometimes when you do that, you're going to find, now that I have to write it up, it doesn't seem as clear to me as it did when we were just talking about it. So it helps us reach the right decision. It explains our answer. One of the real issues in a democracy is, who are those 9 people that nobody voted for telling me that I can't do this, or that the government can't do this? And this is our explanation. This is why we do it. People in Congress, they don't have to tell you why they do anything. The answer is because, 200,000 people voted for me in the House, or because millions of people voted for me to send me to the Senate, and that's why I get to do what I want to do, to represent those people. Well, that's not true in our case. We're doing something because the law requires it, and here we're going to explain it to you. We have to explain it. They don't. The other thing is, it makes it easy for the other judges and lawyers to understand what the law is. That's going to become one of those things in all those books that are on our walls. And so when a judge in Los Angeles or in Pennsylvania, wherever, has a question come up, he can look back and say, well, what did the Supreme Court say about that? Here's what they said. Here is the reason. Is this the same sort of case as I've got here? They've spelled it all out, and you can check it and see. So it's important for that respect as well.
Thank you.
Sure.
In your opinion, who is the greatest Supreme Court Chief Justice and why?
Well, that's an easy question. Every lawyer that you asked should give you the same answer, and that's John Marshall. He was not the first Chief Justice. He was actually the 4th. But he was the first one to serve for a long period of time. And he really established the Supreme Court. I mean, somebody asked the question earlier, why didn't the framers spend more time talking about the courts? They didn't. And so the role that the courts were going to play was pretty uncertain to some extent. They knew what a court was like, they knew what judges looked like and what they did, but how prominent, how important the Supreme Court was going to be, that was pretty unsettled. So much so, you can see it in the architecture here. The first building they built when they moved the capital to Washington was the White House for the executive branch, the president. The second building they started, the Capitol, for the legislative branch, the Congress. The third building they started was the Patent Office. What happened to the courts? Where's the Supreme Court? The Supreme Court building, the one you're in now, was the first one, and it was completed in 1935. The Supreme Court met in the basement of the Capitol for much of its early existence. So the role of the court wasn't settled. John Marshall settled it. He made it clear that its job was to decide, as he put it famously in Marbury versus Madison, what the law is. He made it clear that the decisions of the Supreme Court were binding on the state courts. Remember, the state courts, as I said, they were here before the Constitution. It wasn't clear whether they were going to have the final say or these new federal courts, including the Supreme Court. And through a long series of decisions over his long tenure, he established the Supreme Court as the final arbiter of what the Constitution means. The branch that was going to make a decision that was going to be binding not only on the citizens, but also on the states, and also, importantly, on the federal government itself. So everyone would give the same answer. John Marshall is he's called the Great Chief Justice. He's in a league of his own. And he was a remarkable man. I mean, even lawyers who know, oh, he's a great Chief Justice, he was responsible for establishing the role of the Supreme Court, don't fully know all that he did. He was, among other things, a war hero. He fought at Washington's side under great personal danger to his life. He was instrumental in getting the Constitution ratified, convincing the Virginia legislature to vote in favor of it, which was a close thing. People don't realize that the vote in favor of the Constitution came down to some critical votes in a number of states, and he was largely responsible for getting it passed in Virginia, which was a very important state at the time of the founding, and of course Virginians would say still is. So that's an easy answer. I think everybody would agree John Marshall. You get a lot of debate over who's number 2, but not over who's number 1.
I know you already spoke about what you felt was one of your most important roles or responsibilities as far as delegating who writes the opinions, but I was wondering if you feel that, what are any other special roles or duties the Chief Justice has?
Well, you're right. Assigning the opinions is one of the more important ones. I have the responsibility of presiding at court, calling the court to session and making sure the lawyers don't go beyond their time, and trying to referee when the other 8 justices all want to ask questions at the same time. I have the responsibility of presiding at conference too, starting the discussion and kind of laying out what the issue is before stating what my views are. Beyond that, there are certain administrative responsibilities. I have to try to get the necessary money out of Congress every year for the court's budget. And I have a certain responsibility to defend judicial independence and the rule of law. It's very hard sometimes for judges when they're under attack for delivering, say, unpopular decisions, which is very much part of our job. You wouldn't want judges or courts that just did what was popular. The Constitution is designed to protect people who are unpopular as well as the popular, and they have to go to court and get that type of protection from the judges. So it's hard for a judge who's making an unpopular decision sometimes to defend herself or himself, and I view that as part of my responsibility too, to make sure that judges are not criticized unfairly when they're doing their job, and also to make sure that they are getting from Congress the sort of resources they need to do their job.
Why do we have 9 Supreme Court justices, and is that a good number?
Congress gets to set the number. It's not in the Constitution, and we've had fewer than 9. We've even had more than 9 at different points in our history. But it's been 9 for a long time, and I think it's a good number. I think anything more is too many. You want it to be an odd number, because otherwise you don't want to be dividing up 4 to 4, as happens sometimes if one of the